All right, we are waiting for the stream to get cranking here. Looks like we are broadcasting on Periscope, so we're live on Twitter. We are now live on R&R Law Group. Looks like we're live on Facebook. The only thing we're waiting for is YouTube, and it looks like we're live there as well. Hello, everybody. Welcome back to another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney. My team and I, over the course of many years, we've helped thousands of people facing criminal charges go through the criminal justice system. And what we've decided to do now is actually sort of amplify what we're doing here. We're helping people through the process, but there are still some major issues throughout our criminal justice system that need to be addressed. And so what we have here is a show called Watching the Watchers, where that's exactly what we do. We're identifying misconduct. Hang on one second. We're identifying misconduct from police officers and prosecutors and politicians and basically anybody who's involved in the criminal justice system. We want to hold them accountable because unfortunately what we see happen too often is a lot of these people are sort of masquerading as good guys. They're going through the criminal justice system and they're committing a lot of misconduct, a lot of malfeasance. And the best way to highlight this and the best way to root it out is by shining some sunlight on it, by notifying the general public about what is happening. Now, I'm getting some notifications that YouTube may not be working here, so let's take a quick moment and check. You're going to notice that things look a little bit different on the stream, and so as I'm sort of going through this introduction, we are going to be troubleshooting a couple things. You can see here that the background is certainly different. And I'm trying to identify why YouTube is not showing up. Is anybody on YouTube right now? It does look like we have some people on YouTube, but I'm not sure why it's not showing up on our main channel. Anyways, that's all right. We're going to keep going on with the show, but a couple things. So you can see that there's a new background here. We moved into a new office, and for the last week or so, I have been really trying to put together a new background and try to level up our YouTube production capabilities. And so what you see behind us is the new permanent studio. On the other side of this camera is a gigantic mess of cords and lights and cameras, and I'm still trying to figure it all out, but this is what we're working with today. So if there are any technical problems with this stream, I apologize in advance. Now, the other thing I want to share with you is something happened to me this past weekend that I don't usually like to talk about too much, but I had a birthday, and I'm not a big fan of birthdays. I kind of like to just be left alone a little bit on the birthdays and let them come and pass. Not a big celebration type of guy. And people in my life, they won't let me have that. So the office here actually threw a party on Monday to celebrate my birthday and another person's birthday and a 1-year anniversary. And so we had a little bit of a celebration, but I got a gift that I absolutely had to share with you on the show today because it's something I'm super proud of. So let me show you what I got. This came from a dear friend of mine here. She works here. Her name is Mrs. Harleen. She's awesome. And so they brought out gifts for me, and this is what I received. Let's take a look. Watching the Watchers. That's right. It's a t-shirt. So you can see here it's got our logo, the Watching the Watchers logo right there. And what good would a shirt be without the hashtag on the back, Bad Popo? The Bad Popo hashtag. We call bad police officers bad popo. We call them bad prosecutors, and so on and so forth. So awesome gift. Now, once I end the show and I put this on, I do not anticipate that this ever leaves my body. But that is enough about the introduction. Let's dive into the actual program here. And so I want to start off with going through more Kyle Rittenhouse. This has been a story that I think is really one of the most paramount sort of our time as it comes to self-defense. And when we're talking about gun rights and the freedom to carry firearms with you and to protect your life, protect your property. There's a lot of issues at stake here, and I want to spend a little bit more time on it. Now, I don't want this channel to become the Kyle Rittenhouse channel, but there is some important things, that are happening here that I really want to spend a little bit of time on. So since last week, there have been some developments. Now, on this channel, we've spent a lot of time covering a lot of different aspects of the Kyle Rittenhouse case. If you remember, we did a detailed analysis on the actual incident that night. We talked about the beginning, the first sequence of shots, the first shootings, the second sequence. We talked about the judge who was assigned to the case. We talked about the prosecutors who were assigned to the case. Today, we're going to talk about the defense attorneys who were assigned to the case, because if you've been following this, you know that both of the gentlemen who were involved in actually representing Kyle Rittenhouse are sort of in the middle of their own legal problems, and the same due diligence that we gave to the judge, the same due diligence we gave to the facts, the same that we gave to the prosecutors, we want to give to Kyle Rittenhouse's defense team, because he's going to be working with these guys for the foreseeable future, and we want to make sure he's got a good team in place. So we're going to get to that today. But before we do, let me give you an update on just what's going on with him. So last time we spoke, Kyle Rittenhouse was in Illinois. Now he's still there. He has not been transferred yet back to Kenosha, Wisconsin. You remember this all took place in Kenosha, and he sort of at the end of the video sequence, he's running back towards the police. He has his hands up and he's got a gun on his chest, and he's just sort of surrendering to the police. They drove right by him. Anyways, he left. He went back to Illinois. In Illinois, he had an extradition hearing, which means they were trying to talk about, what it's going to take to essentially send him back to Wisconsin so that he can have his day in court there. So right now he's in Illinois, and he had an extradition hearing that was scheduled previously, but it got moved. There was a continuance in the case, and so it's now rescheduled for September 25th. He'll be back in court on that day for his extradition hearing. Now, that's in Illinois. In Wisconsin, what happened was the judge there actually set a bond. So in other words, the way that this worked, when Kyle Rittenhouse left Wisconsin and went back over to Illinois, the court said, he's due in court. We have new criminal charges for him. He's not here. What are we going to do about that? So they issued what's called an arrest warrant for him. And they said, if you arrest him and bring him back into our custody, we are going to keep him in custody unless he posts a certain amount of money in order to get out of custody. Now, remember, this is very important because Kyle Rittenhouse is 17 years old. These types of cases, these criminal charges, literally take years and years and years to go through the justice system. So if Kyle Rittenhouse is in bond, in custody for the next 2 years, that's going to be a problem for him. It's a problem for any criminal defendant. It's a problem for anybody who goes through the justice system. We've represented many people who've been in these situations, who are currently in these situations. And from our perspective, it's a difficult thing for a person to endure, right? Of course, you, as a common sense person who's never been to jail, you can understand how difficult it could be to go from somebody who, like Kyle's situation, is 17. He's, presumably in school. He's a lifeguard. He's trying to, grow up essentially. And for the next year or 2 years or however long it takes to get him out of custody, his life is on hold. And it's not just on hold, it is being dramatically impeded by the criminal justice system. So this is one of the most critical parts of a case. We need to get him out of custody so that he can get back to life, get back to school, get back to a job, show the rest of the world that this is not somebody who was out running around with an AR-15 just trying to kill people, right? This was a kid who was trying to do something productive, got caught up in a bad situation, did what he thought he needed to do to protect his life and his well-being, and now he's being charged with a crime and he's going through the justice system as a result. So the problem with being in custody for 2 years is that this is a process that is just sort of, I don't want to say it's designed to just deteriorate a person's willpower, but it absolutely does that. The system is sort of meant to just grind people into a pulp so that they have very little choice to do much fighting anymore, right? They're sort of incentivized to take a plea deal, close their case, because if they continue to fight, then they're going to continue to be in custody and they're going to continue to have this stuff over their head for a very long time. So a person in Kyle's position he's got a long road ahead of him. In other words, this process causes people to take plea deals that they may otherwise would never have taken, because they want some finality in their case. They want to get out of custody. They'll take anything. They'll just say, all right, look, yeah, I'll plead guilty to that. How much more time? 5 years? Fine, I'll take it. Because they're just tired of the process. And you have to think about the stress. Kyle's facing some charges that would put him in prison for the rest of his life if he's convicted of all of them. So to have that constantly weighing on your head, it's just incredibly burdensome. So getting Kyle out of custody is going to be a big focus. And there's a lot of work left to be done on that. He's in Illinois. He's going to get transferred back. And what we have seen thus far is the judge in the Wisconsin case. So once he does come back over to Wisconsin, the judge put a bond on his case of $2 million. So you can see that right here. This is a screen grab that I took today from the court's website itself. And you can see a couple items here. So this happened about 2 weeks ago, but Kyle, there was a warrant issued for his arrest. We've already seen that. It was issued by the judge, Mary K. Wagner, who also set a bond of $2 million. Okay, $2 million is a significant bond, but is it really that different, or is it really that inappropriate for Kyle's case? Well, that's what we're going to dive into today. We're going to look at the rules for the Wisconsin statutes that will detail what is an appropriate bond and what is an inappropriate bond. So the judge in Kyle's case did say that it's a $2 million bond. That's a very high bond. I covered this last week, that there's another defendant, Crystal, who is also out of Kenosha, who is also being prosecuted by the same DA, who had I think it was a $1 million bond that was reduced down to $400,000. And we did sort of a case-by-case comparison on Crystal's case and Kyle's case, and we saw that they sort of didn't really match up. Why was she getting a $400,000 bond, but he was getting a $2 million bond? Hers originally started at 1, was dropped to $400,000, and Kyle's is still at 2. So we want to just go through the rules, right? What are the judges looking at? What are the prosecutors looking at? What are the defense attorneys looking at? And we can see if there are any arguments that may justify getting Kyle out of custody without posting that $2 million bond. Right now, one other important thing to note, and this is a long sort of segue here, but it's important to note that this judge, Mary K. Wagner, so this judge who posted this bond here, it really hasn't seen anything yet, right? Doesn't know much about this case at all, other than what she saw from the charges that are going to be posted, or that were posted in the probable cause statement from the prosecutor's office. That's all the judge knows. And from what we've seen here, I looked through the more recent activity on the case, but I don't see a lot of activity. There was a proposed order that happened the day after the warrant was issued, and that's about it. So I really don't know if there has been any sort of movement from Kyle's defense team to file motions to modify their release conditions, or whether they've had any presentations to the Wisconsin court. We just don't know that yet, but we will soon enough. So my point is, Mary K. Wagner, the judge who issued this bond, is sort of probably flying in the dark, or supposed to be flying in the dark. Now, this judge is going to know everything that you see on the news and in the media, but in terms of the concrete evidence that is in front of this judge, they just haven't seen it yet, or probably have not seen it yet, which is why there may be some wiggle room on this bond once Kyle does get transferred from Illinois back to Wisconsin. All right, so now let's talk about the actual, what are the rules in Wisconsin? And they have some pretty good rules that I think are actually favorable to Kyle Rittenhouse's case, but he's not in Wisconsin yet. When he does get there, I think that there are some pretty good arguments that this bond should be reduced down, or there should be no bond, or there should be some other sort of limitations on his ability to be out of custody. And we're going to talk about that. But let's take a look, first and foremost, at the eligibility for release. So Kyle Rittenhouse is in custody. He's going to be transferred back to Wisconsin. What is a judge going to look at when they're determining whether or not to release him from custody? So here we go. This is from section 969.01 of the Wisconsin statutes, and here's what it says. It says, a defendant arrested for the criminal offense is eligible for release under reasonable conditions designed to assure his or her appearance in court, to protect future members of the community from serious bodily harm, or to prevent intimidation of witnesses. So that's a long way of saying there's 3 things that the court wants to consider when they're going to be releasing somebody from custody. 1, is he going to come back to court? Is Kyle Rittenhouse going to show up to court? They need him to show up to court. That's the primary purpose of these release conditions. It's to get him present and going through the process. Does anybody think that Kyle Rittenhouse is not going to go to court? Maybe some people do, but in my mind, that is kind of a no-brainer, right? He's going to go to court. He's a subject of national media attention. This guy is not going to slip under the radar. People are going to know where Kyle Rittenhouse is. The other issue that the court wants to discuss prior to releasing somebody is whether or not there's going to be any issues protecting members of society from Kyle Rittenhouse. So the second major facet is whether they can protect members of the community from serious bodily harm. And again, is this something that Kyle is going to go and shoot more people? This entire situation, in my mind and in our analysis, and it's not just mine, there are many other defense attorneys throughout the country who are saying this is clearly self-defense. So if he doesn't have a history of being proactive and going and finding people to shoot, then, and this is just purely a self-defense issue, that prong, I think, is pretty easily met. And then finally, the law itself says that we want to talk about identifying or protecting against the intimidation of witnesses, right? So on this final last prong here, the intimidation of witnesses. Are we going to see that in this case? Is Kyle Rittenhouse going to intimidate any of these other people? I just don't see that, right? He's a 17-year-old kid. He's in a bad situation, and this is not something that I think he's got, a gang, or he's got the resources that are going to go and really undermine other witness statements in this case. And quite frankly, there really aren't that many other statements. From the government's own probable cause statement, we had the two witnesses who two people died. We had the reporter who essentially, McGinnis, who was actually talking in the probable cause statement and making claims that, in my mind, actually backed up Kyle Rittenhouse's claim. We have an unnamed individual, and then the other victims are just the government. It's just, well, he was there and he shouldn't have been there is what the government is claiming. He shouldn't have had a gun or whatever, the basis of that misdemeanor charges, which really isn't that important in my mind. So that is, those are the three things that they're considering, and I think Kyle Rittenhouse has a strong case for all of those. Now, what's important to note in this statute also is that the government doesn't have to just automatically impose bail or impose a bond. Because Kyle Rittenhouse was charged with some serious things, you sort of jump to that conclusion, right? You just start to say, well, because he's being charged with murder, we got to post a high bond, or really high bond. That may be what the judge was thinking, but really that's not what the law says or what the law requires. Here's what it says. It says that bail may be imposed at or after the initial appearance upon finding by the court that there is a reasonable basis to believe that bail is necessary to assure appearance in court. Okay, so it's necessary to assure appearance in court. In determining whether any conditions are appropriate, the judge shall first consider the likelihood that the defendant appears if released on his own recognizance. Okay, so what does that say? That's explaining, it's saying that the court doesn't automatically have to go and put a bond on Kyle or on anybody. It says that if there's a reasonable basis, so they have to look at the facts and say there's a reasonable basis that the bail is necessary to make sure that Kyle shows up in court. Did that analysis take place? We don't really know, right? The judge just looked at the case very early on in August 28th and set a bond at that time. We've learned a lot more about the case since then. And so this may be ripe for a reconsideration. We don't know if the judge actually did make that reasonable determination whether bail is necessary. But more importantly is that it's not even automatic. In other words, the court can go through, has to, it actually says shall, first consider the likelihood of the defendant appearing for trial if released on his own recognizance. You see that right there? That is the court saying if there's a possibility that we can just let him out without having him post bond and he'll come back, then we don't even need to post a bond, right? We should first consider whether he's going to show up. Otherwise, why do we need to even impose a bond in the first place? So I think just looking at some of those factors, and Kyle's got a pretty good case, and it's going to be something that is going to be very relevant. Now, let's say that the judge does determine that this person is eligible for bail. What are some of the factors that they need to consider? So the law goes on. So that was just the introductory part of the statute. The things that Kyle's attorneys are going to need to be looking at are included further down the statute in a different part of the law. And here's where the law, I think, is really on Kyle's side in a lot of different ways. We can look at the text and we can start to sort of see which ones are in favor and which ones are not. So what I've done here is I've actually copy and pasted the statute from the Wisconsin statutes and put it here in a slide, and I've broken it down into bullet points or numbers so that you can see specifically some of the things that the judges are going to be looking for when they're determining whether or not to release Kyle. All right, so let's go through them. Now, the stuff in green is stuff that I think is sort of favorable to Kyle. The stuff in the red is not so good for him, and the stuff in the yellow is sort of open to interpretation. So let's read through the statute. So let's say the judge says this is a case where Kyle can get bail. We're going to let him out of custody. The court says that if it is imposed, or the statute says if it is imposed, the bond amount shall only be in the amount found necessary to assure the appearance of the defendant. So once again, necessary to ensure, or here to assure the appearance of the defendant in court. Is a $2 million bond necessary to make sure that Kyle appears in court? If they made it a $500 bond so he could get out, would he still come to court? So it should only be the amount that's necessary to ensure future appearance. That's what this statute says. Something that's way too big or way too overbroad doesn't meet those elements of the statute. It becomes more punitive rather than it is helping to ensure that the criminal process is moving forward smoothly. Okay, think about that. If the amount of money is so high, it can be punitive. Now, Kyle has not actually been convicted of anything yet. He's been charged with crimes, but he's innocent until proven guilty. He deserves his day in court. But if a judge posts a bond that is $2 million and there's no way that he can hit that amount, then essentially he's being deprived of certain freedoms, whether you agree with it or not. He's being denied certain freedoms and he hasn't been convicted of a crime. So the judge needs to do a very careful consideration on all of these factors. We're taking somebody who is innocent and we're depriving them of their liberty. So what are the factors that are going into play, and what are Rittenhouse's attorneys doing to make the appropriate arguments to help ensure that his release is secured? So let's go back to the statutes. What they're going to be looking at here is they're saying that the conditions of release may be imposed for the purpose of protecting members of the community. We've already spoken about that. We are also talking about preventing seriously bodily harm. We're talking about preventing the intimidation of witnesses. And so the court goes on, and the statute goes on, and it says that these are the reasonable conditions of release are, right? The first one, which is sort of up in the air for Kyle, is whether the person has the ability to even give bail. So does Kyle have the funds to get out of custody? Can he post a $2 million bond? I have seen no evidence that he comes from a rich family, or that they have the means to even come close to that. I'm not an expert on the actual mechanics of bail and bond in Wisconsin, but I have heard from other attorneys who are familiar with it that if Kyle needs, if it's a $2 million bond, he's got to post the full amount of that $2 million. Does his family have that? I highly doubt it. Is the general public going to be willing or able to help him generate that amount of money? I think potentially. I mean, that is a massive sum of money. We have some of the lawyers for Kyle Rittenhouse, I think, doing some fundraising and engaging in some campaigns to help assist with that. But I've also seen some other headlines throughout the news showing that some of these actual fundraising, crowdsourcing programs and entities and business entities like GoFundMe and some of these other ones, I don't know about them specifically, but they're actually not taking money for this type of a case. And so they're not allowing their platforms to be used to help fundraise for Kyle Rittenhouse, which is, of course, sounds like a double standard to me. I think there's a lot of politics going on in that decision, not necessarily, fairness or equality or any of those things. All right, so let's go back to the statutes. The second factor that the judge needs to consider in determining whether Kyle should be released is the nature, number, and the gravity of the potential of the offenses and the potential penalty the defendant faces. Right? This one is obviously not good for Kyle. The reason is pretty obvious, right? The nature of the offense, they're murder charges. Intentional homicide. He showed up. He intended to kill these people. And there's no self-defense claim. That's going to be the government's position when they're discussing this factor. The self-defense can come into that equation, into that analysis, but still the severity, the gravity of the offense is very high. It's the highest thing that we have, right? And other people are dead. The penalty that Kyle faces are also very severe, very high, right? He can go to prison for life if he's convicted on all of these charges. And then the other bad red factor here is whether the alleged acts were violent in nature. That's sort of debatable. You could look up that statute and decide, what is violence versus self-defense. Violence to me has sort of the connotation that you are doing something that is inappropriate. You're being violent when it's not justified. Violence is unjustifiable. Whereas if you're defending yourself, somebody else was engaging in violence, not you. You were defending yourself. They were the ones who were being violent. You were just being a good person, protecting your life and your property. So I'm not real sure, how that factor goes in, but I think many people would just say, hey, he fired a gun and other people are dead. That is close enough to violence that factor may not weigh in his favor. But I think there's strong arguments that go the other way. Basically everything else, in my opinion, is good for Kyle's case. And again, these are all directly from the Wisconsin statutes. The next we have number 4, the defendant's prior record of criminal convictions and delinquency adjudications, if any. The only thing that we are talking about here, Kyle has some traffic tickets that also happened, I think, in Wisconsin. Very minor. One was going 20 to 24 over the posted speed limit, civil ticket, not a criminal charge. To my knowledge, I don't know of any other criminal history that he has whatsoever. And so that factor weighs in his favor, that the judge can look at that and say, this guy's never been in trouble before. And why, if he's never been in trouble before, then how can he be a danger to the community? This is one aberration. This is not a pattern of somebody who's willfully breaking the law day in and day out. Factor number 5, the character, health, and reputation of the defendant. And, this is an interesting one, right? Because Kyle is super young. Character, health, residence, and reputation of the defendant. He's very young. He basically has no reputation. We know very little about him other than the fact that he's 17. I understand he's a lifeguard. He was there trying to, remove some graffiti and protect some property. And he's got a lot of pro-police Facebook posts and things like that. But other than that, we don't know much about the guy, and nor should we. He's 17. His residence is in a different state, which is somewhat of a concern, but I think we can cure that issue if we sort of craft his release conditions in a different way. The character and the strength of the evidence is number 6. The character and strength of the evidence, which has been presented to the judge. We did a deep dive on this one, right? We went through the case line by line in the probable cause statement. We went through the video. We did an audio video frame by frame analysis on this channel, and it all looks like it favors Kyle pretty substantially. So I think the character and the strength of the evidence weigh majorly in his favor. The number 8, we've got number 7, whether the defendant is on probation, extended supervision, or parole. Kyle has not been in trouble at all, ever. So he's not on probation. He doesn't have any other pending cases, no other pending cases here. He hasn't been bound over for trial after a preliminary examination. He's got nothing going on. He hasn't had a past forfeited bail or violated a condition of release. He wasn't a fugitive from justice at the time of the release. And there's just no evidence that he's a threat to the community at all. So all of these different factors, protecting the community, preventing the intimidation of witnesses, assuring he can show back up in court, I think they all weigh in his favor. Now, they're also in factor number 11. These are not numbered. I just numbered them out for the ease of dissecting this statute. If you look at the statute itself, it's actually just a big, messy word salad paragraph. So broke it down for you here. The policy against unnecessary detention of the defendant's pending trial. So, the idea is that he has not had his day in court, and we want to get him out of custody so that we can, allow him to live his life. He's innocent until proven guilty. Those are some of the factors that I think the court by law, by statute, is supposed to consider. And there are some other things that they can do according to the statutes to really cure any of the other problems. All right. So let's think about it this way. If the court decides, all right, listen, we understand your arguments. We know he set a $2 million bond, but we're going to end up, make your arguments. We're going to release him, but we have to do these 3 things. We have to make sure he shows up to court. We have to make sure he's not a danger to the community. He's not a flight risk. And we have to make sure he doesn't intimidate witnesses. How can we do that? Is there anything that the law allows us to do so that Kyle can get out of custody over these next 2-3 years while the case is pending so that he can live his life and continue to develop as a young man? Well, fortunately, the Wisconsin statutes do provide some alternatives. They give us some options that we can use to craft a good release schedule. So here's what that statute looks like. So it's 969.03. This again comes from Wisconsin. Here's what it says. A defendant charged with a felony may be released by the judge without bail if a couple things can happen, right? They need to ensure that the person appears for trial, and they can impose these conditions to make sure that that happens. So a couple things that they can do. They can place the person in the custody of a designated person or organization. So they could give, basically custody of Kyle to somebody, to his mom, to his parents, to an organization for young men, to a school, a charter school. So, there has to be some organization in the United States who is willing to step in and say, look, we're gonna vouch for this kid. We're gonna make sure that this young man, make sure that he is in our care, and that we're not going to allow him to do anything that's going to impede the goals of the court. They could easily do that. They could also place restrictions on the travel, the association, or the place of abode of the defendant during this time. And so here what we're talking about, well, Kyle's place of address, where he lives, is in Illinois, in Antioch, and he could easily, move. I think it's not far from Kenosha. He could move over to Kenosha. He could put permanent residence there, or a place in Wisconsin, or a place right on the border, or they could craft some sort of option for him and say, look, we're going to let you out of custody, but you've got to do this, this, and this. You got to stay here and do this and report home and do all of those things, which would be significantly better than sitting in custody. They can also prohibit the defendant from possessing any dangerous weapons. So that is a no-brainer, right? Let him out of custody, release him on his own recognizance, and say, you can't touch a firearm. If you touch a firearm, if you're near a firearm, if you're in the same building as a firearm, if you go to a gun store, you're going back into custody. Okay? Don't get near it. That would be a good way to cure. They could release him and say, just don't touch a gun. If you do, you're going back in. I think that would be pretty reasonable as well. They could also require, of course, we've talked about this, the execution of an appearance bond, and they can do other things reasonably necessary to assure the appearance as required and protect the members of the community and prevent the intimidation of witnesses and return to custody at the specified hours. So how do you do this? There are many ways you can do this. There's no reason he has to sit in custody for 2 years. You can do this with house arrest, right? You can just send him home and say you're not allowed to leave home. How do they monitor that? Well, they'll do it with ankle monitoring. They'll put ankle bracelets on. They also have devices that you can install in your home, and you can connect them to a landline. So I don't even have a landline at my house. I have a cell phone. That's the only thing that I use. But there's equipment that you can buy. You put it in your home. You connect it to a landline so they know you're there, and they call you every now and then. You got to check in, make sure you're there. They've got a video conferencing and all sorts of things that they can do to protect that balance. Right now, there are many people who are probably watching this saying, "Yeah, but Kyle's innocent. What the heck are we doing? Why are we going to not allow him to have a gun or allow him to go do certain things? The guy is innocent," which I can empathize with that. But the court has to balance these things, right? The court is going to be saying, well, technically there are 2 people dead, another one shot, and this guy, we don't know much about him, so he's a danger to the community. So they have to balance it. They have to protect the community, make sure he's showing up to court, and protect his freedoms, protect his liberty, make sure that this kid is getting the proper representation and the proper arguments are being made on his behalf, I think is where I'm going with that. And I think it's very important. So eventually this is going to become ripe. We're talking about it a little bit prematurely right now because Kyle is still in Illinois and he's going to be going back to Wisconsin soon, presumably after the extradition hearing, but this could take months. When he does get back over to Wisconsin, they're going to have that $2 million bond and it's going to need to be addressed. This is something that we do pretty regularly at our firm. If somebody comes to our office and they're in custody, we file what's called a motion to modify their release conditions all the time. I mean, it's a very common type of thing. The judge knows about the case just on some of the the basic factors that were available at the very outset of when everything started. But when we start working on a case, we can start to humanize somebody and start to say, okay, yeah, he was charged with intentional murder, but here's the story, right? He's 17 years old. He's never been in trouble before. A couple speeding tickets. He's a lifeguard. He's got a loving family. He's got, not to mention all of the legal defenses in his case. But let's just talk about the human side of this case. And so you make those claims, you go back to the court and you say, look, here's our plan. If you release this individual, here's why it's important. We need him to work on his own defense. We need to do interviews with him. He's going to need to, sit with us and analyze exhibits and do all of this stuff. It's a better environment for his defense to keep him out of custody. Whereas somebody who's in custody, the attorney's going down there all the time, and they've got it's just a big ordeal. So it's a lot easier for his defense. It's a lot easier for him personally, right? He can go back to school. He can get a job. He can show the world that he's actually not a murderer. He's just a young man who's in a bad situation. And so this is super important. And in addition to that, it's just right. It's the right thing to do for his mental health, his mental well-being. To have him sit in custody for the next 2 years is going to be very detrimental to his his whole life is changed, obviously, as a result of this, but keeping him in custody without human contact, especially during these very sort of formative years of a young man's life, that is going to be a tall order for the next 2 years. So the question then becomes, are his attorneys going to be able to handle this? Are they going to be able to go through this process and do a good job? Now, before I jump into this segment, I know that this is going to be something that's probably a little bit unusual, but basically what I want to do is do the same thing that we have done with everybody else who's involved in the case. We went through the DAs, we went through the judge, we went through the different victims of the case. We know who everybody is. But we didn't spend a lot of time on Kyle Rittenhouse's defense lawyers. And specifically, we're talking about Lin Wood. We're talking about John Pierce, who are the two attorneys who have been brought on by Kyle and his family, or whomever is helping him make these decisions. And they're now representing him. And over the course of the last couple of weeks, we've seen some weird allegations sort of bubbling up about these two individuals that in my mind have been concerning. I've been watching this stuff unfold over the last couple weeks, and what I'm seeing feels like it's more about these lawyers than it is about protecting and defending Kyle Rittenhouse. And so what we're going to use the same lens that we used on the prosecutors and the DA, and we're going to look at these two gentlemen and really kind of decipher what's going on. The reason I wanted to take a closer look is because I started seeing some of this stuff bubbling up on Twitter, and I heard some of these kind of weird allegations that these guys were in charge of fundraising for Kyle Rittenhouse, and then they've got a lot of debt and a lot of these creditors making claims against them. So now people have concerns about the money. Is it really going to Rittenhouse's defense fund? Is it really going to be used for his defense, or is it going to be sort of embezzled and siphoned off to pay down some of these past debts? And I started thinking through that. I was, oh my goodness. That is troubling indeed. If they're going to be defense attorneys who are not putting their full force of their careers and their skill sets into defending Kyle Rittenhouse, then they're not the right attorneys for the job. If they're too worried about fighting off lawsuits that are attacking their personal, their businesses, and they've got these really massive outstanding debts, that is a disservice to Kyle Rittenhouse. And that's really the most important thing here, right? I mean, is there anything else more important than that? I mean, these guys' past debts, these guys' past businesses, these media appearances, or whatever that is. That's fine and appropriate to a certain extent in some cases, right? The attorneys are always going to get attacked. Defense attorneys get attacked in general anyways. But what really is going on here is my point. So decided to take a closer look. The only thing that I knew about these two guys before we started jumping into this was what I saw on Twitter. And even then, some of the Twitter posts were curious. And we'll go through some of that here in a minute. But first, let's meet these two defense attorneys, and they are right here. We've got on the left, we have Lin Wood, and on the right, we have John Pierce. And these are both attorneys who've been practicing for a long time. They've got big reputations. They've handled big cases, more nationally renowned cases than I have. And it's not my position to sort of judge the other attorneys' tactics or their techniques. I have my opinions on them, and of course I'm going to share them. But they're on the ground, right? They're on the floor. They know sort of what's going on. But there is a lot of stuff that is sort of muddying the waters to a certain extent. And I'll tell you this: if I can find it, if the internet can find this stuff, the prosecutor's office can find this stuff. the prosecutors will find it. They probably have teams of research assistants who are law school students just diving into this stuff and using it as a tactical advantage in their prosecution of Kyle Rittenhouse. So we're talking about it just to sort of shine some light on it, and then these people can explain it. They can explain it. And quite frankly, I don't want to hear an explanation that just says we're under attack by the left-wing media. Okay, that's not enough. The facts that we're going to get into here today warrant an actual response. Other than that, right? Anything that's just trying to parry off the criticism. Well, that's just the left-wing media. That's just the liberal media. That's just people trying to engage in a smear campaign. That's ridiculous, right? We're looking at actual court documents here. We're going to be here in a minute. So enough of that introduction. Let's take a look at it. All right. So I want to start with Lin Wood. Lin Wood is an interesting defense. He's an interesting attorney. We covered this last week. I wasn't real sure that we even saw much in terms of criminal law experience from Lin Wood. My understanding is he's done sort of a lot more of the higher stakes media representation when it sort of requires a PR hand, then they bring him in. But in terms of criminal defense legal experience, I just haven't seen much of it. Doesn't mean that it doesn't exist. But here's the story. All right, so Lin Wood had a law firm, had a corporation called Lin Wood PC. He had a law practice, right? And this complaint that I'm going to show you was filed by 3 of his former team members. Now, the people who are filing the lawsuit against him are claiming that they were employees and that they should have been compensated and treated as employees. Lin Wood is saying, no, they weren't actually employees. So here is the complaint itself. So you'll see here that this complaint, this is all public record. It's all available on basically any news site. If you try to look up this stuff, Lin Wood, lawyer, lawsuit, whatever that is, you'll find it. It's available. And it was filed by these 3 people, Nicole Wade, Jonathan Grunberg, and Taylor Wilson, against Lin Wood. These are his former employees, right? So he says that they're not, but they say that they are. And we're going to go into it. So here's essentially what happened. Let me give you the nuts and bolts. This is a massive complaint. Like, I think it's like 80 something pages long, very long complaint. I skimmed through a lot of it, but sort of read through the pertinent parts. And here is the gist of what ended up happening. So you have these 4 people who are working together. Lin Wood is the top, and then you've got these 3 other people who are hired on as partners. They've been working together for a number of years, and the allegations are from the 3 people who were, the employees or in the contested position. They are saying that Lin Wood is going in sort of a downward spiral and becoming abusive and erratic and holding these weird meetings at 2 in the morning, 4 in the morning. Weird stuff is going on. So they decided to part ways. So we have these 4 people in a law firm. 3 of them decide, all right, that's it. We're out. We can't take this stuff anymore, and we're going to leave. There's a big case that they were all working on together. So in civil litigation, these cases can last a very long time, years and years and years. And so they have a settlement on a case, and they come to an agreement that the attorneys who put work in on the case are going to be compensated accordingly. And, Lin Wood's going to get money, and they're all going to get sort of compensated accordingly. Well, as they decided to part ways, there was an agreement in place. So as they were leaving, Lin Wood and these 3 people entered into this agreement, a contract that says we're leaving, but here's the compensation we want. We're going to take a couple of these cases that were with the firms with us, and we're going to pay you for that, and you're going to pay us for this. And so they settled the whole thing. There was basically like a divorce agreement, right? You get divorced. They were doing the same thing, and that agreement was entered into place. The problem is that the allegations are that Lin Wood is not honoring that agreement. So this agreement was entered into as a contract. It was signed. It was executed. It was fully official. And Lin Wood now does not want to pay on that. Doesn't want to pay, right? And so Lin Wood, of course, is on Twitter saying that he's being attacked and he's being smeared and all of that stuff. But let's take a look at the complaint itself. All right. So we have here one of the primary allegations from Lin Wood here is that he does not have to pay them anything because they were not employees. That's what he's saying. Now, I'm going to show you some pictures and some emails and some things, and you can tell me whether you think they were employees or not. But that's what the allegation is. So Lin Wood here is the defendant, and he is saying that the stated position is that the individuals were not in Lin's firm at any time relevant because they shared office space and they worked on cases with Lin Wood. They were going to split fees and all of that stuff. He goes on to say that, well, so that's his claim. Now, let me back up here a little bit. So there's another kind of interesting factor here where Lin Wood is saying that all of these attorneys had their own LLCs. He was paying them as 1099 employees. He says, this is not unusual at all. In my second law firm, I was a 1099 and I got paid as that, but I was an employee of the firm. It was just for tax purposes. So that's just something that firms do. It's not unusual. It's not uncommon. It's sort of the way of doing business for certain firms. Just the attorneys are responsible for paying the taxes themselves, which is not a big deal. So Lin Wood is saying they're not attorneys and they're leaving because, for whatever reason, we're going to enter this agreement, but then he refuses to actually honor that agreement because he says they're not employees. Well, in the complaint, the three people who are suing him respond back and they're saying, no, not so fast. There's a lot of evidence that we were in fact employees there, and here's what it looks like. They're saying that there was a website where they were identified as partners on it. Wade, Grunberg, and Wilson were all identified as partners on Lin's websites. His office made public announcements that they were joining the team. They were on the header, on the case caption for every single case that was filed. There were many other things. They got business cards. They got email addresses at linwoodlaw.com. There's emails, there's texts, there's all sorts of stuff that show that they really sort of were employees, that they were partners, that they were part of this firm, and so they're entitled to the same compensation that an employee or a partner would get, right? If they're not employees, Lin Wood is saying he's got an excuse not to pay them, but it looks to me like they're actually employees, right? And so here is another screenshot from the complaint itself. You can see here, this is an actual announcement that the plaintiffs here, the people suing Lin, are filing, and it's saying they're pleased to announce that Nicole Jennings Wade has joined the firm as a partner. So she is now a partner. Okay, that is not sort of a different type of an employment agreement. Now, I'm not an employment attorney. I don't practice in this space specifically, but I do run a business and I do have a law firm with a lot of employees here. And so I know a little bit about this just from my own experience in practicing and building a business. If somebody joins as a partner, their interests are directly connected to the firm. I mean, they're integral to the firm. They're absolutely integrated into that. If somebody is not in that position, and let's say you just want to use them sort of, for certain cases here and there, you don't call them a partner, you call them of counsel. It's just a different designation. It's saying they have their own firm. We work together occasionally. But what we're looking at here is, it looks to me like this is an announcement saying this person joined the firm, right? We have an email address and Wade at Linwood Law. Everything is tying this back to her position there at the firm. And there's more evidence to support that. This is the case caption. So this goes at the top of every single document that's filed with the courts. We've got Lin Wood, which is right here at the top. And then we've got all three of the other people who are listed on the case caption. This is filed on cases this is going into courts. So courts are looking at this and they're saying, yeah, that firm has 4 lawyers there. We do that at our firm too, right? All of our attorneys who are our employees are on our case captions, and those get filed in every court. And in addition to that, we've also got a situation where Lin Wood is taking pictures with these 3 people and he's putting them on the website, right? That's all 3 of the plaintiffs there who were working with him, and they took a picture together and they promoted that on their website. So to me, that looks like a firm. That looks like employees. That looks like a longer term ongoing business relationship. And if that is the case, then it does seem to me that Lin Wood owes those people some money. If you read through the complaint, it's a very long complaint, highly detailed, but it sort of draws the connection, and it explains if they're employees, they're entitled to the compensation. They're also entitled to the compensation just due to the fact that Lin signed an agreement with them at their departure. There was a departure agreement, and he should honor that. So that's concerning. That's concerning to somebody like me, right? If I was the type of person who hired a bunch of people, had them do a bunch of work, and then essentially parted ways with them and didn't pay them for that work, that is not a good thing. That is not what a good, honorable person with integrity does. So the allegations here are pretty serious. The complaint goes on, and it says here that the complaint is going to move forward, and it's going to start to sort of delineate some of the misconduct or the malfeasance that they're claiming Lin Wood committed against them in this complaint. And again, this complaint is public record. These are not my words. They are the complaint's words. So let's look at the complaint itself. So throughout late 2019 and January and February 2020, abusive, incoherent phone calls, voicemails, texts, and emails by defendant Wood to plaintiffs were made in the middle of the night. They were the norm. All of these erratic communications have a few things in common. Most of these emails profess that God or the Almighty was commanding his actions. Many were stating his refusal to pay the plaintiffs one thin dime, and virtually all were abusive. Now, I want to point out that in this complaint itself, these three people who are suing Lin, they worked together with him for some time, and they make a point in this complaint to say that they are trying not to air out his dirty laundry. In other words, there's a paragraph in here. It says, listen, there's a lot here. We're going to tell you some of it because we have to, but our intention is not to be overly sort of exposing of the private conversations that Lin Wood had with his employees, right? Some of that stuff I understand. Some of that stuff is, you want to have certain confidences in people. I have no question in my mind that there are things that I have said or done in office meetings that probably were, over the top or offended somebody, or, it's something I shouldn't have said, or, things happen, right? We're all human. We all make mistakes. I get that. But what we're talking about here is something significantly more than that. It's more than just being angry or being snappy when somebody asks you for something. I already answered that, or one of those types of things. This is really strange behavior and really kind of troubling to a certain extent. So the complaint goes on and on and on, but my point was, this is not something that they're trying to rub his nose in it. They're just saying, look, we gotta make our claim. We've got a ton of evidence, and so we're just going to start laying it out here. Complaint's like 75, 80 pages long, and there's a lot. Okay, I'm not going to go through all of it because it's pretty bad, but I did highlight some things that I think are pertinent to what we're talking about here. And again, this is pertinent because this is Kyle Rittenhouse's defense lawyer. This is somebody whose job should be to his clients, right? And if he's being distracted by all of this other stuff, he's not going to be able to do as good of a job for his clients. I understand that people can chew bubble gum and walk at the same time, but this is something that is a big deal. And it's currently, in my mind, it's distracting from Rittenhouse's case. It's distracting from his defense, which is a big problem. Okay. He's a young man. Who knows how this all happened? But anyways, let's go into the complaint itself because it's interesting. All right. So the defendants say during a 3.5-hour phone call, there was Woods referred to himself as Almighty, offered to fight the individual plaintiffs to the death. He demanded the plaintiffs' undying loyalty. He threatened to hurt the plaintiffs. He offered the plaintiffs stay in the firm, and he called plaintiff Grunberg a Chilean Jew and demanded that he admit he does not look like the other lawyers in the firm. Unfortunately, the list goes on, as reflected by the ongoing pertinent portion of the transcript of a call, except as indicated by brackets and double quotation marks. The words are defendant Woods. All right, so that was an interesting segue into this big wall of text. Now, I want to point out this is just one example of many. I mean, this is a very long complaint. There's pages and pages of these types of text and phone calls and emails. So these people who are suing him, the plaintiffs, they have everything. They've got emails, they've got voicemails, they've got phone calls, they've got text messages, they've got it all. And they're just systematically laying this out one after another, and it does not look good. All right, so here is what they're detailing this. They're saying that 2 hours later, so they're going through a series of events, and they're saying, on this day, he did this. On this day, he did that. On that day, he did this. And so we're picking up here from one of those stories. They're saying 2 hours later at 3:45, Lin Wood emailed them and 9 others, and he continued his incoherent allegations. He said with his belief that God was somehow commanding him or directing him to accuse the plaintiffs, and repeating his threat never to pay the plaintiffs for anything for their services. He began the email by stating, "God has given me permission to be profane in this email," which is my last email of the night, and additionally stating in material part as follows. So this is Lin's actual email to these people. He says, "You damn dumb MFers, you have now subjected yourselves and your families to the fact that you are all guilty of federal crimes, and you are going to be ruined financially if necessary in civil and criminal lawsuit. You committed computer fraud today and possibly bank fraud. Your lies and fraud upon law firms and your employers are going to come back quickly to haunt you for the rest of your lives. You effed with the wrong guy. You effed with Lin Wood. Bad effing choice. Here are the findings of your final judgment day on earth for today. The day after my Valentine's Day massacre." This goes on. He says, this is another voicemail. He says, "Let me tell you something, you little snotty ass son of a bee. Don't write me back and tell me you're taking care of your son. Your son's looking into the eyes of a damn lowlife, cheating, lying, probably a criminal defendant. How could you do this to your family? FBI is not going to play around. You've all engaged in computer fraud. I don't give a damn whether you did it or if Nicole did it. I know who did it, and you got redacted involved. You've ruined everybody's life. You're not going to get one thin dime from me." The reason why that is in bold is because he's already entered into an agreement to pay them. He's already agreed to pay them. And now he's saying that he doesn't have to pay them, which is certainly concerning. "You're not going to get one thin dime from me. Sue me. I don't think they'll allow you to file lawsuits like that when you're behind bars. Somebody better call me, put their baby down, and give me a damn truth. If there's going to be any mercy shown by anybody for you, including the FBI, blah, 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 blah. Somebody's going to jail. Don't go with him. Quit playing your games, you snotty ass little bastard. You came in here and rammed your damn mouth in my office and yelled at me. You're lucky I'm not with you right now, Taylor, because I do to you what I do to X. I'd beat your ass with a switch till you couldn't sit down for 20 effing years," is what he says. And, it just goes on and on and on. This complaint is very long. There's a lot of it in there. There's one line about, threatening to have sex with somebody else's wife. And it's a lot of really, really bizarre behavior, really bizarre language. And we're seeing some of that actually from his Twitter account. I mean, quite frankly, this is something that is, available, I think, kind of for everybody to see. And so let's go over to his actual account. Let's take a look at it. Now, this is somebody, he's tweeting almost all day long. I mean, he's very active on Twitter, and you can see here. So let's go to Lin Wood, attorney at Lin Wood. Light always overcomes darkness. Truth always overcomes lies. And he's got, I looked at it earlier today, Jack and my friends at Twitter. So again, he's making it about himself. Fight back by going to our home pages and retweeting messages you believe would be beneficial to others. Here's what he says here. This was an interesting thread. So he posted this today. He says, this is from Lin Wood. Now, also keep this in mind. So the complaint that I just shared with you, that was filed by one side. That was filed by the three people who were suing Lin Wood. They have full rights and full opportunity to file a response back. So they can respond to that. And when they do, when Lin and his team respond to that, I will, of course, talk about what is in the response. I will, they should address everything point by point. We can take a look at some of their claims and see what his response is back to them. That being said, I'm not optimistic that he's going to have a good explanation for his behavior. All of this stuff is documented in voicemails, text messages, and phone calls. I don't know why he's speaking this way to them. It is, not particularly good or professional way to do things or to treat people. I've worked for guys like this, and it's not good. And they don't particularly do very well because you can't treat everybody, like a bully and expect to get ahead in this world. It's just not a good way to do things. Not a good way to live your life. But that's sort of what we're seeing in that complaint. That's my take on it. So when we go back to his actual Twitter account, we're going to see that he says, too many lawyers now make big decisions driven in large part by big and medium-sized law firms. They need to generate revenue. My profession is at its best when we as lawyers take on the controversial client or issue and do so without fear of negative publicity or threats of harm. Lawyers must always place the client's interest first and foremost in order to uphold our oaths as officers of the court and to adhere to the fundamental principles and ethics of our profession. Too many lawyers have forgotten the oath taken upon the admission to the bar. Money explains why public at large and so many clients have lost faith in our profession. Many young lawyers face crucial issue of whether they want to work for money or for the client. Stated differently, do they want to be a businessman or professional? The love of money has eroded my profession's principles. The love of money is truly the root of all evil. Businessmen make money, professionals make sacrifices. It is difficult to find Atticus Finch in my professions today, which is which is very curious, right? We just looked at the complaint. He's just threatening that he's not going to pay them. He's claiming that they're not employees when, to me, it looks like they're pretty clearly employees. They got business cards. They're on your website as partners. They had email addresses there. They were on your case captions. I mean, you're essentially claiming that these young lawyers are trying to take advantage of you, or they're too hungry for money, but the complaint is saying that you were the one who was abusive and you didn't pay them. So we understand what the front-facing Twitter account looks like, but the complaint doesn't quite back that up. Now, again, if he can respond to this and he can say what he needs to say in order to explain away their claims and their allegations, great. We're going to give him full opportunity and the full time to address that. I mean, if he wants to come on the show, if he wants to come on any show and address him, I'd love to hear what his explanation is for it. But to sort of, post comments saying that other people are worried about money when it seems like he's the one worried about money is sort of the pot calling the kettle black, as they say. So that's Lin Wood. And I happen to agree with him, right? Lawyers must always place the client's interests first and foremost in order to uphold their oaths as officers of the court. I completely agree with that, but we're just not seeing much of that as it relates to Lin Wood, not here anyways. So let's take a look at the other gentleman who was involved in this case. And of course, we're talking about Pierce Bainbridge. We're talking about John Pierce. John Pierce is the other gentleman that we had spoken about. And, he's got some issues too. We have to say it. We just have to call it out. Now, John Pierce is nobody I know personally. I don't know much about the guy other than what we're learning about him. I have seen him appear on Tucker. I've seen his video. I think we played some of that the last time he was on the phone with Kyle Rittenhouse on this channel. But a lot more is coming out about this guy as well that is troubling. The primary focus here is Kyle Rittenhouse deserves an adequate defense. He deserves proper representation. And we just saw with Lin Wood that there's some allegations of some instability there, and some pretty good evidence from what I can see to back that up. We're going to see what his response looks like and whether he's going to address any of those things on the merit. Same type of situation with John Pierce. John Pierce is a civil lawyer, from what I could tell, not a criminal lawyer, but he's helping Kyle Rittenhouse on his case. Now, I have no doubt that John Pierce is intelligent and could handle a criminal case if he needed to, but I don't see that he's got any experience from it. I know he's not from Wisconsin. Neither of these guys are. So my guess would be that they know very little about Wisconsin criminal procedure. I sure don't. They probably know very little about the judges and about the juries there and how they sentence and what the plea offers look like. And they probably don't have personal relationships with any of the prosecutors there. So, there's a lot of concerns just at the outset with these two guys representing Kyle Rittenhouse, just because the subject matter doesn't line up very well. These guys are civil attorneys. Kyle Rittenhouse has a criminal case. So why are they working on it? Well, I don't know. That's something that Kyle and his family probably made a decision on that regard. But as more and more comes out, and we're starting to see that, where there's smoke, there may be some fire. We have to ask the question, right? Is it time to reassess his defense team, and how is this going to work out for him if he does, and how is it going to work out for him if he doesn't? All right, so I want to share with you this link that I found over on Medium. Medium.com is a pretty great website. There's a gentleman over there by the name of Don Lewis who wrote 2 different articles that go into great detail about some of the problems that John Pierce is having in his life currently. And again, my point in going through this is not to rub his nose in it and to smear him or the specifics of his life or his case. It's just to highlight a fact, right? If we know this is going on, the public at large knows this is going on, the defense knows it, this guy Don Lewis knows it's going on, the prosecutor's offices are going to know this is going on. And this is going to be troubling for Kyle Rittenhouse. If these guys are focused on other things, they're not going to be focused on his case. That's my only concern here. So it's important to know that this is what's going on. So here, Don Lewis says that there's been all of this information going around, these allegations that John Pierce was leading some of the fundraising for Kyle Rittenhouse, leading it for his defense, his legal defense fund. And because he's so badly in debt, there were allegations that he was going to sort of take some of this money and apply it to his past debts. Now he comes out and he says, total fake news. Pierce Bainbridge PC has zero debt. So keep that noted there, right? Pierce Bainbridge PC, zero debt. I have stepped off the Fight Back board to avoid any potential conflict. Of course, the firm will have to be paid for some of his work and expenses so we can keep the lights on. Fight back, free Kyle. All right. So here is where Don Lewis goes through this in great detail. He says that the reported $70 million debt. All right. So financial picture of Pierce, Bainbridge, Beck, Price, and Hecht LLP is not pretty. The firm's reported debt is $70 million. All right. So you're going to see this a lot. Pierce, Bainbridge, and we're going to see a number of different sort of entities that are being created. So it looks like he's just sort of creating new entities. He's having one legal entity that accumulates a bunch of debt. He folds that entity up and then moves into a different entity and takes on new debt. So it's sort of like a Ponzi scheme. It was to a certain extent. It's kind of what it feels like. I'm not saying that's what it is, but it kind of feels like that to me. So here is what Don Lewis is saying. He's saying, okay, so something was going on November 7th, 2019. There was a Rudy Giuliani hired Pierce Bainbridge to represent him, and he actually did some deep dives on this. So he pulled an income and expense statement. He went through this. Now, again, this is all right on the internet. You can go to his article on medium.com and pull all of this stuff. But he summarizes it here. He says Pierce owed over $1 million in taxes. He owed his former spouse's mother $27,000. He owed Citibank $90,000. No investment incomes. His cash deposit accounts were only $10,000. Fair market value of all of his personal property was $0 or negative, actually. He has $49,000 of expenses every month. So essentially, he's got nothing, right? He files his income and expense declaration, and he has very, very little assets. But he's also doing this interesting thing where he is sort of changing the names of the law firms sort of from one entity to another. And there's this timeline that Don Lewis puts together here where he says, okay, here's kind of how this has been going on. He's got all of these actual lawsuits from these different cash advance companies who are suing Pierce Bainbridge and John Pierce and personally, and all of these different enterprises: Pierce, Bainbridge, Beck, Price, and Hecht, Pierce Burns LLP, John M. Pierce Enterprises LLC, JMP Enterprises, John M. Pierce, right? All of these different LLCs, because they owe a bunch of money. So Slade Advance was one of these organizations where $500,000 in upfront cash was going to be given to John Pierce and these entities in exchange for future receivables. So this is just a cash advance. So they're saying, hey, John, we're going to give you $500,000. We know that you're going to make $750,000 back, and so we want all of that money. We're going to give you $500,000 now. You pay us back $750,000. No problem. Those are just example numbers. I don't know what the actual numbers were in this case. Well, when John John Pierce and his enterprises didn't pay that money back, this lawsuit was filed. So they filed Slade Advance, sue him for that. Same story with this other lawsuit. We've got the Supreme Court. We've got the West Coast Business Capital. They provided $260,000 upfront cash, and they wanted $387,400 back in future receivables. So the same deal, and it's the same people. Pierce, Bainbridge, Beck, Price, and Hecht, LLA, Pierce, same people. John Pierce Enterprises, John M. Pierce personally. So, between the two of these, you got $260,000 up front. He owes $380,000, almost $400,000 on that. Then we got $500,000 here, probably in exchange for future receivables with a much higher number. So he's probably looking at $750,000 that he owes just between those two lawsuits. He's got another one, right? He's got another one with Creative Capital Funding, who's essentially doing the same thing. Hundreds of thousands of dollars in upfront cash provided in exchange for future receivables. So he's just going around and he's getting a lot of cash advances, and then he's getting sued by the people who loaned him the money. We got 3 lawsuits, and we got full complaints here that Don Lewis has gathered, which is troubling behavior. We've got more of these different screenshots. We've got here another Karish Capital LLC, whereby $2.5 million upfront cash was provided in exchange for future receivables with daily repayments of $37,500 until $3.7 million was paid back. So he borrows 2.5, repays back 3.75, and in just recently, in July 22nd, 2020, the New York Supreme Court entered a money judgment for $3.99 million against John Bainbridge, or John M. Pierce Enterprises. So one of John Pierce's entities now owes $3.9 million, and you can see that here right in the breakdown from the New York case filing, right, towards Karish Capital. So between the 3.9 and another, $750,000, we're looking at almost $5 million that this guy is in the hole on. And now he is representing, Kyle Rittenhouse. And this just goes on and on and on. So what Don Lewis is claiming happened here is that he would just form new articles of incorporation. So in May 2020, he's got all of that past debt on those old companies. And so now what he's doing is he's just forming a new company. He's saying, oh no, we have zero debt. Obviously we have zero debt. We just formed the company. We haven't incurred any debt. So this is the articles of incorporation that were filed for Pierce Bainbridge, which is the firm that we're hearing about for Kyle Rittenhouse. And they've got on May 20th, this was filed. It's a brand new articles of incorporation. I mean, basically nothing in there, right? Just the absolute bare minimum that you need in order to form the articles. And he's got, these finance statements. He's got other lawsuits from, individuals suing John Pierce, another complaint here. Another complaint here. It just goes on and on and on. And it is not a good situation, right? And so we ask the question, is John Pierce in this for Kyle Rittenhouse, or is John Pierce in this for John Pierce? Or is he in it for something else? Is there another reason why he is, really so gung-ho about representing Kyle Rittenhouse? Is it because that this case is going to be sort of a launch pad to something else that's going to help him cover these past debts that he is accumulating so quickly and moving companies around? So it's concerning, right? If just like Lin Wood said, if this stuff is distracting from the representation that Kyle Rittenhouse should be getting, that is a problem. He needs to have, competent legal representation with people who are highly focused on getting Kyle Rittenhouse the justice that he deserves and getting him out of custody as soon as possible. So that's what I wanted to cover today. Let's take a look at the chat. So let's take a look at the see what some comments we've got popping up here. All right. So Never Trust a Lawyer says, why is he not in jail for fraud? It's because he is a lawyer. Well, it's a good question. Yeah, it's a good question. He may be, he may have some concerns about being investigated for some fraud or for some financial maneuvering, who knows? But I think that's what sort of Don Lewis's position was, or what his statement was. Is John Pierce in this for something else? Is there something else he's trying to do here? I hate to say it, but this reminds me very closely of the Michael Avenatti stuff, where Michael Avenatti was representing the woman who was claiming she had sex with Trump, or maybe that's confirmed now. I forget what it was. I forget Stormy Daniels. This may have been the situation where Michael Avenatti was so badly in debt, and he was so hurting for money and exposure and fame, and he wanted to parlay his representation of Stormy Daniels into something else. Parlay that into a book deal, or parlay that into a media show. There were even people talking about him running for president. Remember that? And now he's I think he's in custody now for trying to extort Nike or one of those things. I forget what it was specifically, so don't quote me on that. But this is a concern, right? You've got attorneys who are very clever and who can make multiple LLCs and really maneuver things around. Now they are, trying to rob Peter to pay Paul, or however that phrase goes. That's what it feels like to me, and it's certainly concerning. A Fowler says, looks like a Ponzi scheme. Excellent work. Thanks, brother. Well, I mean, he beat the Rittenhouse case to even consider the civil suit. He has to beat the Rittenhouse case to even consider the civil suit. Any confirmation that Jacob Blake is guilty of any of the crimes he's accused of doing yet? So my understanding is Jacob Blake had his arraignment from a hospital bed, and so he's appearing on the new charges for the sexual assault case. I haven't looked into the facts on that. I do want to do an update on Jacob Blake because I think there is some more interesting stuff that has come out specifically about the original allegation. So I haven't looked into that, so I don't want to dive into the details on that just yet. Bill Ekman says, seems like these two clowns are trying to gain some buzz to use this case to try to secure a big fat bag with future books or some BS. That's what it feels like to me. I mean, it really does. It feels like these two guys are more interested in posting on Twitter almost all day than they are representing Kyle, unfortunately. You can look at either one of their Twitter accounts and you can see a lot of that. All right. So any other comments? Let's see. The Second Amendment allows people that would otherwise be unable to protect themselves to protect themselves. The right to bear arms is synonymous with self-defense, and that comes from Exit 5398. I think that is a good point. Great. Now Kyle is surrounded by a couple of drama queens. That comes from Gordon G. And it does seem like that. These two guys, it's really weird. They're always talking about themselves, and they're not so much focused on Kyle. Could it be a smear campaign against Lin Wood since he took on the media houses and now Kyle? Yeah, I mean, I'm always open for that. Like, I'm always open to that suggestion or that idea. So as I said, Lin Wood is going to be able to file a response to this. And it would be my suggestion, my recommendation, that he addresses every single one of those complaints on the merits. And he says, look, yeah, I have a temper. It's okay to have a temper. You can't be abusive. You can get mad about things. But some of the language I think in there is really just inexcusable. I don't know how he's going to be able to respond to that, but I'm sure that he will. Let's see. Any other comments? All right. I've got a lot of comments. Johnny Boy, will the people working with Lin Wood is the people that sue CNN, not Lin Wood? I'm not interested in an employee versus an employer spat. Neither am I. I'm not interested in that, truthfully. Brett Hogan says that this is boring. I agree with that. It is boring. It's not about that underlying interaction, right? I really don't care specifically what happened with Lin Wood and these three people who are suing him. What I do care about is Lin Wood is the attorney for Kyle Rittenhouse. And in my mind, he's being sued for a lot of money and he's got a lot of other things going on. And all he's doing on Twitter is talking about other things that are not pertinent to Kyle Rittenhouse. So it is boring. It's not relevant to the Kyle Rittenhouse case. And I do not think that it's productive. So if there's a takeaway on this stuff, it's maybe we should look a little bit more closely at these two people who are representing somebody in a case that I think is very important. So it's a seminal case for self-defense and firearms and the Second Amendment. It's going to be a big deal. And I want to make sure that he's got competent representation. Not two people who are being sued every which way from Sunday, who are just trying to figure out how to pay their electricity bills because they have no money. We want people who are with solid, reputable law firms, people who know how to handle the media, people who know how to represent a case or handle a criminal case in the state of Wisconsin, in the state of Illinois. Neither of these guys are from either of those states. So we just want competent representation. That's all I'm asking for. And it may be time for a change to happen. Let's see. Any updates on the Prude case and the case with the guy got the bat who was shot in Walmart? Daniel Prude's case. No, I have not. I haven't seen anything change on that. I think that one's kind of, well, that's not true, right? So I'll have to look into that. I'll do an update on the Prude case. Is there any way you can help Kyle? That comes from Kenneth Reeder. I'm trying to help Kyle just by simply doing this show. I'm trying to sort of add some stuff to the conversation and help people think about things in a different way. That's what I'm trying to do to help. I don't know how qualified I am, quite frankly. I'd never practiced in Wisconsin law. I would be happy to help in any way that I could, but I just don't. I don't know that it's it's being asked right now, but I'm happy to. I mean, I know the case very well. We've been covering it for a long time. You should do a video about the death of Stephen Dolkamore. Basically died the same way as George Floyd in April. I'm going to look into that. I appreciate that. This case isn't about the Second Amendment. This comes from Zulu. He says it's about the specific event. The Second Amendment won't be affected by the outcome. I hope that's true. I hope that's true. We are going to see, and so we had a lot of comments today. I appreciate that. We're going to wrap up the show now. Remember, we're going to be here again next week live at 4 o'clock p.m. watching The Watchers live from our new studio. And as a reminder, if you haven't already, and you need some help with a criminal case, or you know anybody that needs help with a criminal case, tell them to grab a copy of my book. It's called Beginning to Winning: How to Fight Your Case and Succeed in the Criminal Justice System. It's got a ton of information, all these different strategies and different things that you can do if you've been charged with a crime. It's available on Amazon, so you can pass that around. Otherwise, thanks so much for tuning in to this show. I know it wasn't the most interesting show because of sort of the details on the bond and a lot of law and a lot of legal stuff. A little bit of a slow news week, which is a good thing. Finally, every single week, it feels like everything's been happening so quickly. Every day I wake up, there's a new story, a new story, a new story. So I'm glad that there aren't more people being killed by the police that we have to talk about today. That's good news. But it does give us some opportunities to really do a deep dive on Rittenhouse. I want to make sure he gets out of custody, and I want to make sure he's got good, competent lawyers who care about him and his case more than they care about themselves and their own cases. So thank you so much for tuning in. We will be here again next week, 4 p.m. Do me a favor, hit the subscribe button if you haven't already done so. Any other feedback you want to leave here is great. If you like the stream, if you don't, just let me know. We're trying to always kind of up level and get better at doing this type of broadcast. So I appreciate it. Thanks so much for sharing the show. We'll see